Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Welcome, everyone, to this episode of Michael Brown Unplugged. Glad to have you with me. In case you were looking for yesterday's episode of the podcast, there was not one because I was traveling and only arrived in Denver late. So, frankly, just didn't have time to get one done. And, it's kind of interesting when you start doing podcasts, it becomes this addiction. And when you don't get one done, it drives you crazy because it's like, oh, my gosh, people are going to be looking for it and you don't get it done. And not that I've got like a bazillion downloads, but my downloads and my plays are great. And so missing just a single day drives me crazy. Plus, it puts me behind in terms of all the things that I want to talk about. So let's get to the situation. Now, the situation I want to talk about today is about the FISA court. According to a new declassified ruling from the United States Foreign Intelligence Surveillance Court, the FISC, FBI personnel systematically abused National Security Agency mass surveillance data in both 2017 and in 2018. Now, the ruling is 138 pages. It dates back to October 2018, and it was only unsealed this month. And the court ruling is fascinating, particularly for a lawyer, but I think also for the average citizen, because it offers us this kind of rare look at how the FBI has been abusing the constitutional privacy rights of U.S. citizens with what can only be described as alarming regularity. The court ruling is also, when you read through it, it is amazing. It is a stinging rebuke to the FBI's overreach of its ability to search surveillance intelligence databases. Now, before we go any further, I want to go back to, because people often say to me, well, look, Brown, you were a part of all of this with the Patriot Act, the creation of the Department of Homeland Security, the creation of this surveillance state. And while I had a minor part in most of this, my part was really more about FEMA and response to man-made disasters, natural disasters, terrorist events. Nonetheless, the Department of Homeland Security, the transition team, and those committees that I worked on within the White House did have a part in setting this up. And I'll never forget that one of the reasons that I was comfortable but yet a little queasy in terms of the Patriot Act and the surveillance rules that we were setting up was simply this. And I think I've given this example before, so if you've heard it, bear with me. But the whole idea was that the National Security Agency would be able to monitor conversations of known terrorist suspects or just known terrorists. So that if a known terrorist was calling from Baghdad using a particular payphone and they were calling another terrorist, or for that matter, anybody else, it didn't make any difference. But I want to keep it to that terrorist in Baghdad using either a cell phone or a payphone to call somebody in another country other than the United States. Let's set the United States aside for a moment. If that known terrorist was calling anybody else, the NSA had pretty much free rein to monitor that conversation because the FBI, the Department of Defense, the Central Intelligence Agency had all identified this particular terrorist. We'll call him Mahmoud because he's calling from Baghdad. We had identified that particular individual as a known terrorist or a suspected terrorist. So we said, yes, you can monitor those phone conversations because it might help us stop the next attack. And the whole mentality post 9/11 was we have to stop any future attacks. So that was kind of the general rule. The known terrorist in Baghdad using a cell phone or a payphone or any other communication device calls somebody else in another country. NSA, you're free to monitor that conversation. You're free to capture that conversation. You're free to capture all the metadata about that conversation. Have at it, because that's somebody that is not operating in the United States, which would invoke the Fourth Amendment. Now let's take Mahmoud and let's decide that now Mahmoud is going to go to that same cell phone, use that same payphone or whatever else, and he's going to call Michael Brown. He's going to call me. The rules that the NSA was supposed to operate under was this. You can capture that phone call, but before you can do anything with it, you can't listen to it, you can't analyze it, you can't do anything. You've got to figure out, and they have certain rules and procedures, and they have certain algorithms. Okay, this cell phone called Michael Brown. He called Michael Brown's cell phone at 303-XXX-XXXX. But the phone call only lasted 5 seconds. Well, at that point, there's probably nothing in the conversation. And has he regularly called Michael Brown? No, he called Michael Brown one time. That does not put a red flag on that phone call because Michael Brown, as a U.S. citizen, is afforded Fourth Amendment protections against unreasonable searches and seizures. So if the NSA or the FBI or anybody else, if they could make a case on that one single few-second phone call that they needed a warrant to listen to that phone call, they would have to go to the Foreign Intelligence Surveillance Court and get a warrant because that phone call involved Michael Brown. Now, most likely, neither the FBI nor the NSA or anybody else is going to get a FISA warrant to listen to that particular phone call because Michael Brown doesn't appear on any watch list, at least at the moment, as far as I know. I mean, hell's bells, who knows? But I don't appear on any of those watch lists. I don't appear on any database anywhere. And in fact, if they actually do a search of my cell phone number just to find out who I am, they're going to go, oh my God, this is the former Undersecretary of Homeland Security. That must have been a mistaken phone call, or he must have butt dialed or done something. We're not going to touch that one. But let's make the facts a little more convoluted. Let's say that Mahmoud in Baghdad continues to call my cell phone. Now, if I haven't blocked it, if I continue to get phone calls from Baghdad where, Mahmoud's, speaks to me in Arabic or Farsi or whatever it might be, and I don't understand the phone call, at some point I'm going to block the phone call. I'm going to block that number so that if Mahmoud continues to try to reach me on my cell phone, he's going to go straight to voicemail. It's going to be a blocked number. And pretty soon, even though there might be multiple calls to my cell phone number, the NSA and the FBI are going to figure out he's butt dialing Michael Brown, and we can't figure out why the hell. There's no reason to elevate this, and there's nothing in the algorithms that would take those phone calls and flag them so that some bureaucrat sitting in at a desk at the NSA would say, oh, maybe we ought to listen in on this. Maybe we ought to look at it. It's never going to make it to that level. But let's change it a little further. Mahmoud continues to call me on my cell phone. I don't block it. I take the phone calls. We start having conversations that last 2 minutes, 5 minutes, 30 minutes, whatever it might be. Now a known terrorist, a suspected terrorist, is calling me on doesn't make any difference whether it's a regular basis, like, every Monday at 4 a.m. or every Monday at 6 p.m., but he's calling me on a somewhat regular basis, every few days or maybe twice a month, whatever it might be. And you have the additional factor of the phone calls are lasting more than a couple of seconds. There's actually conversation going on, or at least it appears to the algorithms that there's conversation going on. Known terrorist calling an American citizen. That invokes the Fourth Amendment. I am entitled to be protected from unreasonable searches and seizures under the Fourth Amendment. That includes wiretaps. That includes listening to my conversations. That includes downloading the conversations and transcribing them and having them read by some bureaucrat at the NSA. That's where the U.S. Foreign Intelligence Surveillance Court comes in. And that's where, if the FBI, the CIA, the NSA, if those phone conversations, through the algorithms, through word searches, through anything else, indicate that, hey, we have probable cause. We have probable cause to listen to what Mahmoud is saying to Michael Brown because there is somewhat regularity and the phone conversations are lasting more than a few seconds. They're lasting 2 minutes, 5 minutes, 30 minutes, whatever it might be. Now, from the government's point of view, I would argue that there is probable cause to at least investigate why is Mahmoud calling this particular cell phone number in the United States, and why does it appear, according to the algorithms and the metadata that we're collecting, why does it appear that there are regular conversations going on between Mahmoud and Michael Brown? I would argue, even in my case, if I'm having regular conversations with Mahmoud, a known terrorist, or even a suspected terrorist, somebody that the CIA is monitoring in Baghdad, yeah, I think the government has a reasonable suspicion, and they can now go to the Foreign Intelligence Surveillance Court, and the FBI can ask for a warrant to do one of two things: wiretap, or at least go back and listen to the old phone conversations that have been captured by the NSA and are being stored on NSA servers but have not been touched by human hands or human ears. Nobody's listened, nobody's analyzed, nobody's done anything. So now we have to go to the Foreign Intelligence Surveillance Court and get a warrant to do that, because the elements that are required to do so have been met. Known terrorist, talking to a U.S. citizen, regular basis, more than a few seconds. It appears there's regular conversation going on between a known terrorist and a U.S. citizen. Even if it's me, I would argue that's a reasonable suspicion. That's enough to show probable cause to go get a FISA warrant. You've heard of the FISA warrants, the Foreign Intelligence Surveillance Act warrants that are authorized under FISA for the FBI or the CIA or the NSA to listen or to go back and listen to old phone conversations, to analyze them, and to see if there's any actionable intelligence that they can use. Now, that is a very broad, that is a 30,000-foot level, because to even get to that point where some goober at the NSA is now going to transcribe or listen in or analyze, listen for keywords, look in the metadata, do all of that sort of stuff, there is a series of steps that the algorithms go through to flag those conversations before it even gets to the level of some goober sitting at the NSA actually doing that analytics. But the broad description still fits. So let's go to the Foreign Intelligence Surveillance Court itself. It is a super secret court. It traditionally approves each and every request that law enforcement agencies such as the FBI make. It's almost, in my opinion, at times acting like a rubber stamp. But they found that employees of the FBI searched data collected under Section 702 of the Foreign Intelligence Surveillance Act in an inappropriate and potentially unconstitutional manner. The court said that these abuses, including accessing NSA surveillance data to look into the online communications of U.S. citizens. Let's just stop there for a minute. That's what I was just describing about the phone calls to me. Accessing the NSA surveillance data to look into the online communications of U.S. citizens, actually including this case astonishes me. It actually included FBI employees and their family members. So if you say to yourself, well, this is never going to happen to me, they don't listen to me, you're full of crap. Because this case actually involved the FBI looking into fellow employees and FBI family members. All told, there might have been tens of thousands of these improper queries, all of them carried without any reasonable suspicion of a crime or any suspicion of illegal activity, none of which posed a risk to national security. Moreover, many of the FBI's backdoor searches did not differentiate between U.S. citizens and foreign intelligence targets. In other words, they didn't make a distinction between Michael Brown and this known terrorist that was making the phone calls in Baghdad. Simply put, the data was available to search, and the FBI simply took advantage of every opportunity to query the NSA intelligence database. Here's an example. The FBI employees routinely used mass surveillance data to investigate potential witnesses and informants. Let's go back to 2017. In that year alone, the FBI conducted over 3.1 million searches of surveillance data compared to, now think about this, the FBI, the domestic criminal investigating arm in the United States, conducted more than 3 million searches of surveillance data. That's compared to only 7,500 combined searches by the CIA and the NSA. Now, to me, that's really troubling because under current FBI operating procedures, this surveillance data can only be searched if there is a reasonable suspicion of crimes having taken place or clear risk to national security. In other words, that data had to show something that would indicate there is some sort of actionable intelligence that shows a risk to U.S. national security. And still, the FBI employees and the FBI contractors were at times searching the database to see what information they could find on U.S. citizens not at all connected to foreign intelligence matters. Let's use me for example. Let's say that phone calls from me to a friend of mine in Washington, D.C. We do a lot of texting between each other. Sometimes we pick up the phone and call each other. We might talk for 15 minutes. We might talk for 30 minutes, just depending on what we're talking about. They may have captured that data. I can tell you that he and I have never talked about anything. I can't think of any time we've used code words or anything else. Oh, we might have mentioned Homeland Security or something about, hey, remember that time and blah, blah, blah. And that would be the extent of it. Nothing that would be actionable intelligence. And yet, in short, the FBI was violating our privacy by abusing access to NSA surveillance data with warrantless searches, clearly in violation of the Fourth Amendment. Now, reading through the case, probably the most contentious and, in my opinion, controversial section of the Foreign Intelligence Surveillance Act is that Section 702 that I mentioned earlier. Yes, it went into effect in the wake of 9/11. Under Section 702, it became possible for the NSA to conduct monitoring of online communications involving foreign nationals in bulk. What that means is they could do vast sweeps of communications involving foreign nationals. And the NSA was empowered to collect as much foreign intelligence information as it needed to protect America from a potential terrorist attack. But here's the problem. That led to the situation where communications involving people like me might also be included in any intelligence sweep and then stored in the massive NSA databases. And at some point, that intelligence data could be searched, which is apparently what was happening, at least according to the court in this ruling. Now, under the current FBI guidelines, of course, those searches could only take place if there were reasonable suspicions of crimes or terrorist acts taking place. And any communications involving U.S. citizens were supposed to be minimized to the greatest extent possible so that private conversations involving completely innocent people would never be reviewed. It would never be listened to. It would never be analyzed by U.S. intelligence operatives or U.S. intelligence officials. But we find out now that's not the case. You've heard me talk about that. I think free speech, Second Amendment, yes. I'm just a lover of the Bill of Rights. But one of the hallmarks of our constitutional system is the Fourth Amendment, which prohibits unreasonable searches or seizures. Now, in practical terms, that means that law enforcement officials or intelligence operatives from the FBI have to get a warrant in order to search private property or private communications. But in the real world, that's what's supposed to protect Americans from having police show up at our doors and start searching the premises for just any reason or for just no reason. Instead, they're supposed to go to, this is why I always say law enforcement is a difficult job, as it should be. They first have to go to a court, get a warrant, and then show up to search the premises or to listen in on the conversations. That is what makes the uncovered FBI abuses so troubling from a privacy perspective. Over the past 2 years, and as far as we know, maybe even longer, the FBI was essentially able to go on a fishing expedition. That's the actual phrase used in the court ruling. The FBI was able to go on a fishing expedition. They were able to check out the emails or other online communications of us without getting a warrant in the first place. And the thing that really bugs me and that offends me personally is when we were going through all of this and having all of these discussions and the hearings and the internal discussions about FISA courts and FISA warrants and how we're going to stop the next attack, we thought we were putting in safeguards to protect communications from being searched improperly. How naive of me. I should have known that they would find a way to abuse the system. But here's what's probably most troubling. The FBI, NSA, CIA, and other members of the IC, the intelligence community, they've developed a number of workarounds in order to use NSA surveillance data for their own purposes. Now, there have been a lot of cases, for example, where data and information collected from NSA surveillance data had been entered into evidence as part of U.S. court cases, even when no FISA warrant had been obtained in advance. So if there's, I think, one takeaway from this declassified court ruling, it's that the current surveillance program has got to get reined in. Now, I want to make a distinction here because the entire scope of FISA, the Foreign Intelligence Surveillance Act, that was signed into law nearly 40 years ago in order to give the federal government the ability to monitor communications of non-U.S. citizens on foreign soil who are communicating with Americans in the United States on matters of national security. But I think what we did back in 2001 and 2002, we extended it too far. Instead of only being used to monitor nefarious foreign agents, identified terrorists, suspected terrorists, it's now been expanded via Section 702 to include the monitoring of U.S. citizens. And when you think about the growing power of the NSA, because what they can do now is they can monitor both upstream and downstream communications. Well, what that really means in layman's terms is that now the NSA is able to monitor any form of communication so that any communications that we do, text messages, phone calls, emails, anything is now subject to possible review by the intelligence community. Now, I'm not surprised by this, but of course the FBI says, oh, you know, we're going to reform our procedures and we're going to eliminate unconstitutional data queries. Well, if we couldn't trust you then, why do we trust you now? Well, that might be a good start. The problem is with Section 702 of FISA remaining in effect until 2024. Nothing's going to happen to Section 702 because Congress isn't going to do anything on its own, I don't think. I'll monitor it and see. But I don't think Congress will do anything to review Section 702 until it's required to do so in the year 2024. And it's quite likely that the intelligence community will simply find new workarounds to the system. So I think here's the result. I think you and I have to wake up to the unsettling reality that vast surveillance states, vast surveillance systems can actually exist in a republic as well as in Orwellian authoritarian societies. It's kind of scary when you think about it. And the scarier part to me is that despite this court ruling, despite the fact that it's now public, you would think that members of Congress, Rand Paul might jump on it because he's a big privacy guy and he's a big anti-surveillance guy. But you would think that all 535 members of Congress You would think that the president himself, that somebody on the staff would bring this to his attention. And I know the argument is, but if it's helped stop an attack, there is no evidence in this ruling. There's no evidence that any of this domestic surveillance stopped a terrorist attack. I'm sure that they can make that claim somewhere because they can always make that claim. Just like TSA likes to claim that if somebody forgets to take a gun out of their backpack or their briefcase, that somehow they've stopped a terrorist attack. Well, that's bovine feces, and you know it and I know it. The frustration for me is I don't see any impetus on the members of Congress to do anything about this. I'll continue to monitor the case. I'll continue to see what's going on, but that's the situation right now. Thanks for listening to this episode of Michael Brown Unplugged. You know the drill. I'd actually ask you a favor. Don't hang up yet. Don't turn me off yet. I really do want to ask you a favor. I need to increase the awareness of this podcast, and the best way for me to do that is for you to share it. So if you would share it, tell your friends, send them an email. If you go to iTunes or if you go to the iHeart app, there's a place where you can get the link to the podcast. Do me a favor. Copy that link and text it to friends that you think might enjoy it. Email it to friends. Post it on your social media site. Post it to Twitter. Post it to Facebook. Post it wherever. Because I want to grow this. And I'll tell you an inside story about why I want to grow it. I'm going through a incredible rebranding of the podcast, my speaking engagements, and everything else. And the more I can get that momentum growing now, so that when we do the rebranding, I'll give you a little hint. You've probably heard me say at the beginning and at the end of this podcast, using the phrase, the situation. Well, there's a little hint about the rebranding. So help me get the word out. Make sure you send the link to your friends, family, enemies, whoever it might be. Let's get the word out about Michael Brown Unplugged or the situation. Talk to you tomorrow.